All right, sir, can you tell me your name on video there, please?
Vincent Michael Ryan.
Okay, we'll go on the record in People versus Brian. This is case number 244964. That's all right.
Vincent Michael Ryan.
If I get counsel, put your appearances on, please.
Brian Ziegler on behalf of the people, Your Honor.
Thomas Seeger on behalf of Mr. Ryan.
Okay, this is set for a status conference here today. Mr. Ryan is appearing by Zoom by prior approval of the court. Mr. Seeger, can you tell me the status from the standpoint of the defense?
Yes, Your Honor. Your Honor, it's my understanding that Mr. Ryan is going to tender a plea to failure to report a dead body, which is a one-year misdemeanor, in exchange all other counts and enhancements which we dismissed.
Okay, Mr. Ziegler,
It's a fair statement to offer, Your Honor.
do you have a PAC code for that?
That code is 333.28412. It's a one-year misdemeanor and or $1,000 fine.
All right, thank you. Mr. Ryan, were you able to hear that?
Yes, sir.
Okay, have you had an opportunity to speak with your attorney, Mr. Seeger, about this plea agreement?
Yes, sir.
Okay, and did you want to go forward with that as they've stated here on the record today?
Yes, sir.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. Ryan, are you currently on any kind of probation or parole?
I am. I'm on parole.
Okay, and is your agent aware that you're entering this plea today?
Yes, sir.
Okay, are you going to face any additional penalties for violating your parole because of this plea?
No, sir.
Okay, that's something you've already addressed with them?
Yes, sir. This case predates my parole, so it does not affect it whatsoever.
Okay, thank you. And then you understand that the maximum possible penalty you could face for this charge of, I'm sorry, again, what is it?
Failing to report the discovery of a dead body, Your Honor.
Okay. You understand the maximum penalty for that charge is up to 1 year and or $1,000 fine?
Yes, sir.
With that in mind, what is your plea to that charge today?
Guilty.
Right now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify yourself at a trial if you wanted. You understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Correct, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said on the record here today?
No, sir.
Is it your own free choice to plead guilty?
Yes, sir.
Are you pleading guilty because you are guilty of this charge?
Yes, sir.
All right. This incident occurred a couple years ago. It looks like almost 3 years ago. Is that right? Back in 2021?
Correct, Your Honor.
Okay. Was that November 3rd? Does that sound about the right date in 2021?
I can't recall the date, but I do know it was in November.
Okay. Do you have any reason to doubt that that's the correct date?
No, sir.
Okay. And on that date, did you discover the body of a person that you knew or had reason to know was deceased?
Yes, sir.
And was that here in Kalkaska County?
Yes, sir.
Did you fail to report that occurrence to law enforcement?
Yes, sir.
Did you report that to anybody in the,
No,
with
sir.
authority? Okay,
No, sir.
all right, thank you. Mr. Ziegler, are the people satisfied with the factual basis?
I am, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Ryan, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Given the circumstances, Mr. Barrett, if we could just have like a misdemeanor report just describing, really, that's what I'm looking for, is a description of the offense.
Absolutely.
So somebody from the probation department here will be in touch with you, Mr. Ryan, to do a pre-sentence interview. So just make sure you follow up with them. And then, of course, stay in touch with Mr. Seeger, your attorney, okay?
Yes, sir.
Yes.
Your Honor, can we get a phone number for?
Do you have a number where you can be reached?
Yes, sir.
Can you give us that number?
231-489-6434.
Okay, thank you. Mr. Seeger, anything further we need to address on that file today?
No, Your Honor.
Mr. Ziegler.
No, Your Honor.
Do you have any questions at all, Mr. Ryan?
No, sir.
Okay, you're free to disconnect at this time. Thank you.
Thank you.
People versus Holwick, case number 244965. Ms. Holwick, if you can just come right up to the podium there, please. Mr. Seeger, the record should reflect Ms. Holwick's present here in the courtroom today. Mr. Seeger, can you tell me the status of this file?
Your Honor, it's my understanding that Ms. Holwick is going to tender a plea to an edit count 2 of larceny 200 to 1,000, which is a 1-year misdemeanor. Additionally, Your Honor, it would be treated under HIDA, and so the felony would be dismissed.
Mr. Ziegler?
Fair statement of the offer, Your Honor.
All right, do you have a PAC code for that new charge?
750.3564A as in Adam.
Thank you. Ms. Holwick, have you had an opportunity to speak with Mr. Seeger about this plea agreement? You have not? You want some time to talk to him before we go forward? Okay. Mr. Seeger, do we have any other, do you have anybody else that we can take that's waiting?
Ms. Payne is here, Your Honor, for an arraignment.
Ms. Holwick, why don't you just have a seat for now, and we'll give you an opportunity to speak with your attorney before we go forward further with your case. Ms. Payne, if you can come up to the podium, please. You're Heather Payne, is that correct?
Yes.
Okay. All right. Ms. Payne, you're here before the court today for a show cause hearing that alleges that you committed a technical violation of your probation in that you failed to make adequate payments towards your court-ordered obligations. Do you understand why you're before the court today?
Yes.
Agent Barrett or Mr. Ziegler, how do the people want to go forward today with this case? Do we just need to arraign Ms. Payne and set this for hearing?
I think so, Your Honor.
Yeah, okay. So Ms. Payne, I'm going to go through a few things with you with regard to your rights. Would this be a first violation?
To my knowledge, it is, Your Honor.
Okay. So Ms. Payne, first of all, you do have the right to have a hearing as to whether or not you should be found guilty of violating your probation. You also have the right to have an attorney present at any subsequent proceedings. If you can't afford one, one would be appointed for you. Because this is a technical violation, the maximum penalty you could face would be up to 15 days in jail. Do you understand that?
Yes, Your Honor.
Okay. How did you want to proceed? Did you want to see if you would qualify for a court-appointed attorney and have this set for a hearing?
I think that she's not looking for a hearing, and I did have an opportunity to speak with the Department of Corrections. In any event, Your Honor, she would just admit that she generally has not paid her court costs and fines consistent with the warrant.
Okay, is that correct, Ms. Payne?
Yes,
How you wanted
yes,
to proceed?
I mean, I'm slowly catching up, so other things have been taken care of, and now it's getting easier to start paying on these fines. So I mean, even if I could set up a payment plan, I don't know if that's a possibility.
All right, we need to kind of go through the technical, my procedural requirements here. Can you
Okay.
raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
You understand that by pleading guilty, you're going to be giving up the right to have that hearing? I just need to answer for both. Okay.
Yes,
And you understand that, again, you could be sentenced up to 15 days by admitting that you committed this technical violation.
yes,
Okay. With that in mind, what is your plea to that charge?
guilty.
Okay. Has anybody threatened you with anything to get you to plead guilty?
No.
Has anybody promised you anything or offered you anything in exchange for you making this plea today?
No,
Is this your own free choice?
yes,
Okay. And you indicated you're currently still on probation here in Kalkaska County, is that correct?
yes,
And you're aware that there are outstanding fines and costs that were assessed at the time of sentencing, and that one of the conditions of your probation is that you have to pay those?
yes,
Okay. And have you failed to make those payments in full since you were placed on probation?
yes, they are not paid in full yet.
All right, so the court will accept your plea to the technical violation. And then Agent Barrett, I mean, you've heard Ms. Payne indicate she'd like to engage in some type of payment plan, and what are you looking for in terms of the
Yeah,
resolution?
at this point, Your Honor, I believe the only reason she's been extended was due to failure of paying, in full. No other violations. I think she's completed all the other terms that were required of her. I think Agent Wagner is just looking for a resolution to where she can get paid in full as fast as she can. So we don't have to keep extending her merely for that reason. So if it's some kind of payment plan that's gonna fulfill that obligation, we have no objection to that. So, but the most expedient way to get this done is if she could just pay it in full, which that might not be the case for this month.
Okay, so do we know what the current balance is? Do you have that?
Your Honor, I don't have that in front of me.
I can get it from
Oh,
here.
I know it's just under,
Okay.
or under 1,000, something like that, I don't know. 872.60.
And I'm assuming like 675 of that is for costs and attorneys.
Yes.
All right, so one of the things that I frequently do, Ms. Payne, when people have been successful on probation, they haven't had any violations. And the only reason they're being extended is for payment. The court can waive the attorney fees and court costs. And so based on your performance on probation and the fact that you didn't have any violations, to me, that indicates that you've complied. And that's simply a financial issue. So the court will waive those court costs and attorney fees. So that's going to take care of a big chunk of that. So that should make it more manageable for you. I think I can't do the math.
So court costs, attorney's fees, and the late fee. My math is right. I write it down. Looks like it would be about $100, somewhere in the range of $100 for, so she still owes the state minimum. Oh, don't she paid her state minimum?
She has paid, she has $42 left on the crime victims. Court costs, attorney's fees. The late fee, which will be gone, so it looks like it's gonna be, like I said, around. She's already paid some of her court costs.
Okay.
$43, it looks like.
Okay, so
Thereabouts.
when can you make that?
How much?
$43
$43, that's Friday.
on Friday?
Yeah, I get paid every 2 weeks and this Friday is my payday, so.
Okay, so, first of all, in terms of a sentence, the court is, going to order that you make that payment in full within the next 14 days. And at that time, Agent Barrett, if you want to let Ms. Wagner know, we can discharge this payment from probation once she's made that payment.
Absolutely.
If not, then the court will set this for a sentencing hearing next month and we'll address how to go forward from there. So is there any doubt in your mind that you can make that payment?
No, I got it. I can
Okay.
do it. Yeah,
All right.
for sure. Thank you so
Okay.
much.
Because things could get worse if you don't, so
Yeah, no,
be honest with me, like if you don't think you can do it, tell me
no,
now.
no, I have a full-time job.
All right.
I can pay this right.
Okay.
Yes.
All right, very good.
Thank you.
Anything further on this? Thank you.
Thank you very much.
You're ready on Ms. Holwick.
You're ready?
Yes.
Okay.
Okay. All right. Thank you very much.
Ms. Holwick, you want to come back up to the podium there? Go back on the record in Ms. Holwick's case. Do you have an adequate opportunity to speak with your lawyer? Okay. Did you want to go forward with that plea agreement today? Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Ms. Holwick, are you currently on any kind of probation or parole? And you understand that the maximum possible penalty you could face in this case would be up to 1 year in jail, and what was the fine, Mr. Ziegler?
Up to $2,000, Your Honor.
Up to $2,000 fine and 1 year in jail. Do you understand that?
Yes.
With that in mind, what is your plea to that charge today? Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have a court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No,
Has anyone promised you anything other than what we've said here in court today?
no,
Is it your own free choice to enter this plea? Are you pleading guilty because you are guilty? First of all, how old were you at the time that this occurred?
I just turned 18.
Okay. And this happened on February 20th of 2024, is that correct? Okay. And this occurred at school, is that right?
Yes.
Okay, is that a school here in Kalkaska?
Yeah.
Okay. And did you take some candy? in that school? And do you have any legal right to take it at that time? Did you have any permission to take it? And was your intent in taking that candy to use that candy for yourself?
Yeah.
Mr. Ziegler, are you satisfied with the factual basis?
I'm satisfied with the factual basis to the charge, which the court could apply to lesser offense, Your Honor.
Mr. Seeger.
Yes, sir.
Okay. Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger.
No, sir.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes,
Yes, sir.
Ms. Holwick, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. This matter will be set for a sentencing hearing. You'll be notified of the date and time of that hearing. You're going to meet with Agent Barrett before you leave court here today for to set up a pre-sentence report. Again, Agent Barrett, if I can just get the facts of what happened here. And then, of course, make sure that you stay in touch with your attorney before that sentencing hearing. Okay, do you have any questions? Mr. Seeger, anything further today?
No, Your Honor.
Mr. Ziegler?
No, Your Honor.
Okay, thank you, that's all for today.
Your Honor, Ms. Atlin appeared. I have not heard from Mr. Smith since following trial, and I suspect that he's probably not going to appear primarily because he was homeless when he was prior to, he was somewhat homeless, and then after he was released, I don't really think he had anywhere to go. So, I don't have a contact number or an address or any way to contact him.
I guess my big question on this, what was there, my recollection was that we took care of the sentence. Did we not do that?
We did not.
I think it was just inadvertent, Your Honor, but he had maxed out on his time.
Okay,
And so I was hopeful that even though he didn't appear, that we could just do it in absentia. I would concede as his attorney that the court could sentence him.
Mr. Ziegler?
I have no objection to that, Your Honor. He is well over the max of what he was convicted of.
Okay. I'm just gonna pass this for a minute. I don't, if he doesn't appear, he doesn't appear, but I do want to just look at it from a procedural standpoint when a defendant fails to appear for sentencing. What the court's options are. Obviously, I don't want to belabor it either, but I also want to make sure I'm not just doing things without the authority to do them. So
Understood.
let's just pass that for a moment.
Miss Atlin is here though, Your Honor.
People versus Atlin, case number 244946. And the record should reflect Ms. Atlin's present here in the courtroom today. Can you just come right up to the podium, Ms. Atlin? This is the date and time set for sentencing in this matter. Ms. Atlin, did you have a chance to go through the pre-sentence report and talk to Mr. Seeger about that?
Yeah, I did.
Mr. Seeger, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Challenges to the scoring?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Do people have any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, I largely support the recommendations contained in the PSI. I think a term of probation is appropriate, just to ensure that Ms. Atlin continues on the right course. She clearly has had and has struggled with substance abuse issues in her life, just based on her criminal history. So I think that term of monitoring is appropriate. I also agree with the recommendation in the PSI that some upfront jail would be appropriate. I think the guidelines would call for that. Her history would call for that. And I think some level of punishment and deterrence is appropriate, just given her history and the nature of the offense here. So I would ask the court to impose 90 days jail up front, hold whatever other time in abeyance, and then give her an opportunity on probation to demonstrate that she can live substance-free. It's my understanding, based on her history, that she had a period of time where she was free from substance abuse, and this was somewhat of a relapse for her. So I think she has the capacity to address these issues in her life, and I'm hopeful that this gives her the opportunity and the motivation to do so here.
All right, thank you. Mr. Seeger.
Your Honor, I would just ask the court to hold any time in advance. I I do recognize that Ms. Atlin does have a criminal history. It's all primarily related to substance abuse addiction, and she continues to have that problem. But at least during the course of her bond hearing, she's done very well. She has passed all her screens. I think the court can understand because it's the court at 1.10 for sobriety court that people do in fact have relapses, even when they maintain periods of sobriety. Ms. Atlin's probably a little bit different than maybe some of my other clients, in as much as she does have very good family support. Her father's in court with her today. He's consistently been involved in her life. He's been consistently coming to court whenever she's had problems. So he's very supportive. I know that she is attempted to make a good faith change of her life, wherein there have been periods in her life wherein she has not had employment. She now currently has employment. And I guess my larger concern for Ms. Atlin is because she's responsible for some children. She does have valid employment. I'm concerned that if she goes to jail for a period of time, that she takes some steps backward, which maybe that's warranted just based on her history, maybe that's warranted based on the criminal conviction itself. But I guess it's generally been my experience that when people come out of jail and they no longer have anything, they've lost their stability, i.e. having valid employment, they struggle, and it's probably easy to have a relapse in that moment, which I really wouldn't want to have for her. I think that a term of probation would be appropriate so the court can monitor her. If she had done horrible while she was on bond, that would probably be an indication that she would not be a good candidate for probation. But I think in this particular instance, probation would be appropriate. I think that's something that she would be able to digest and benefit from. I also think that going to jail would probably be a very large detriment to her, in as much as she is responsible for children and also she has valid employment. And again, I can't express enough my concern that if she loses her employment, that, you know, and I'm sure there are other jobs that she could get after she's released, if that was the order of the court. I want people to have stability. I want them to be valuable and working and trying to find some other way than coping with problems that maybe they have. And if she didn't have good family support, or if she didn't have valid employment, if she had done poorly on bond, maybe the court might look at it differently. But I think Ms. Atlin's life has changed, and I think she's somewhat at a moment in her life where either things go the right way for her or they go the wrong way for her. And because she has shown that she's willing to at least take her bond seriously, at least try and work through the problems that she has, I think that the likelihood of success with probation is much greater than maybe some other files. And I'm hopeful that everyone can change that as a substance abuse problem. Now, I've known Ms. Atlin for a period of time, and she has been involved with a lot of different people who are troublesome. I think a lot of that has to do with drug addiction, but I also think that she has now distanced herself from those people, and it has improved her life tremendously. So I'm hopeful that the court will give her one last opportunity to see how well she does on probation. If she does poorly on probation, clearly the court can impose whatever jail sentence or prison commitment I think is necessary. But I think that at least in this limited instance, the jail is not necessary to impress upon her the importance of remaining sober. And I would note that I think it's probably important to distinguish people who are selling drugs and people who are just passively using them. Which, I use this as an example, and I tell this to my clients all the time. I continue to smoke cigarettes. I know that they're bad for me, but I continue to do it. So I can understand why addiction is a difficult thing for Ms. Atlin. She knows that it's bad for her. She knows that it's self-destructive behavior, but she wants to change. She's expressed remorse for it. She understands how this is changing her life, and she also understands, just based on her record, that every time you come into court, it's not necessarily a good look. And as much as the court is understanding, many times, at some point in time, it just has to do something else. But I don't know as if she's gotten to that point quite yet where the court has no other remedy other than just to give her an opportunity to put this on probation. But I think she wished to address the court about this.
Thank you, Ms. Atlin. Anything you wanted to say?
Yeah. First, I'd like to say that I'm sorry for my actions. For disappointing my family, the court, and the community. And I've been clean for a little over 4 years, and this is my first relapse since my clean time. I've now been clean for 131 days. I started a new job right in town, waitressing. I got that job like a month and a half ago. My 3-year-old just started preschool. I've been going to NA meetings weekly, which I now found, a different group of friends, like the sober community. I've been doing outpatient counseling with my program, who's been helping since my relapse also. Yeah, I guess I just want the opportunity to keep showing everyone that I can get that clean time again. And I'm sorry for my actions too. Pretty much made a fool of myself, so that's all I have to say. Thank you.
Okay, I did read through the report. I'm familiar with the circumstances of this case as well as your background and circumstances as well. Looking at that information along with what the lawyers had to say yourself, Ms. Atlin, Mr. Seeger hit a lot of the points that I was going to address, and I agree with a lot of what he had to say on your behalf in terms of mitigating factors here. Number one, I think the people you surround yourself is an incredibly important factor to your sobriety. If you're staying with and hanging around with sober people, you're much less likely to have relapses because the opportunity isn't there, and those people are involved in things that don't involve using substances, and that's, you're with them, you're not involved in those things. So I think that's an incredibly important factor, which you probably already know. I think looking at your past record, it involves all possession charges. You're not involved in trafficking. This looks to me like you're just a person who's got a substance use disorder that needs to continue working on it to limit and hopefully eliminate relapses going forward. I also agree with Mr. Seeger's statement that you're running out of chances every time you come back into court and have one of these charges. You're running out of opportunities for probation and community sanctions because you've had 4 jail sentences and 3 times on probation. So at some point, the court runs out of options to keep you here, and you end up winding up with a prison sentence and prison guidelines. And I don't think that's where you want to go at your age, particularly with young children. I think you have, based on what I read in the report, demonstrated that you do have the capacity to stay sober, and I'm going to give you the opportunity to continue that through probation. I'm going to sentence you to a little bit longer length of probation. If you do well on probation, you have the opportunity to be discharged early. And I'm also going to hold the jail time over your head, because I agree with Mr. Seeger. You're doing a lot of right things right now, and I don't think that 60 or 90 days in jail is going to get the community anything out of this. I think holding that in abeyance and providing for that, hopefully as a motivating factor for you to stay clean, will work better than having you go to jail right now. And that's largely going to be up to you, of course. So the court is going to sentence you to probation for a period of 24 months. The court's going to adopt as the conditions of the probation all the terms and conditions listed in the report. The court is going to order that you serve 6 months in the Kalkaska County Jail with credit for 21 days served. The court's going to hold that time in abeyance to be used at the discretion of the court. So if you violate your probation or test positive, I can impose some or all of that jail time immediately, whether or not you're eventually found guilty of a probation violation. So that's a significant consequence. You don't stay clean. And again, I'm hoping that that's going to be a motivating factor for you to stay clean. The court is going to order that you pay a crime victim's assessment of $130, supervision fee of $30 per month while you're on probation, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to appeal this sentence. got those from Christie and Kendall's and Mr. Seeger. And Mr. Seeger, if you can just let me know once Ms. Atlin's acknowledged receipt of her appellate rights.
Returning a copy of her appointment, returning a copy of it as well.
Thank you. Does she need to check in with me before she? Okay, so just check in with Agent Barrett and good luck to you going forward, Ms. Allen. Mr. Vermetten, were you ready with Mr. Stevens' case?
Yes, sir.
Okay. Versus Daniel Stevens, case number 244954, and if I could have both copies of your appearances on the record.
Good morning, Matt Vermetten on behalf of Mr. Stevens.
Looks like this is Mr. Stevens' first appearance before circuit court on this file. Mr. Vermetten, can you tell me what the status is from the defendant's standpoint?
Yes, I can, Your Honor. Mr. Ziegler and I were working toward putting together a sobriety court program for Mr. Stevens, and it wasn't until early October that Mr. Ziegler found out that Kalkaska is no longer referring to sobriety court and had offered a plea agreement that my client is accepting.
Okay, what are the terms of that agreement?
So the terms of the agreement is to plead to OWI 2. I'm asking that the court allow sentencing to go forward today. This has been going on since February, but I understand if the court is uncomfortable with that, but that is my understanding of the plea.
It's fair statement.
Okay, Mr. Ziegler, what's the people's position in terms of sentencing here today?
Your Honor, it is Mr. Stevens' third OWI offense. His two priors are in early 2000s.
Well, I'm just wondering, are you objecting to proceed?
I'm not objecting, Your Honor. I don't have a strong position regarding its misdemeanor, so I will leave it to the court's discretion. I don't oppose it.
All right, are you going to be requesting jail time?
I'm not, Your Honor.
All right, Mr. Stevens, have you had an opportunity to speak to Mr. Vermetten about this plea agreement?
Yes.
Okay, and what we've said here on the record today, is that consistent with what you've discussed with him?
Yes, Your Honor.
Is that how you want to proceed?
Yes.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Mr. Stevens, are you currently on any kind of probation or parole?
No.
And you understand that this is a 1 year, is that correct?
That's correct, Your Honor.
You understand that the maximum penalty you could face for OWI second would be up to 1 year in jail? Yes. All right. With that in mind, what is your plea to that charge today?
He's guilty to OWI 2.
Take the plea.
Say guilty.
Guilty.
Yeah, thank you. Mr. Stevens, you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand that you have all those rights.
Yes.
You understand that by pleading guilty, you're going to be giving up those rights, including the right to have a trial. I'm not sure your voice got.
Yes.
Okay. Has anybody threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here in court today?
No.
Is it your own free choice to enter this plea?
Yes, it is.
Are you pleading guilty because you are guilty?
Yes.
This happened back on February 21st of 2024. Is that the correct date?
That's correct.
On that date, had you been consuming alcohol?
Yes, Your Honor.
And after you consumed alcohol, did you operate a vehicle, motor vehicle on Boardman Road here in Kalkaska County?
Yes, I did.
And did you have any blood or breath tests to determine the level of alcohol in your system?
Yes, I did.
Remember what that result was?
0.17.
Do you have any reason to doubt the accuracy of that result?
No.
Had you consumed enough alcohol that day that you believed that your ability to operate that vehicle in a safe and normal manner, that you weren't able to do that because of your consumption of alcohol?
Yes.
Mr. Ziegler, are the people satisfied with the factual basis?
Your Honor, did you go over a prior?
Oh, I'm sorry. Had you previously been convicted of operating while intoxicated in December of 2002 in district court here in Kalkaska?
Yes. That was,
Yes, and also, you need both priors.
I guess technically, yeah,
Technically, I think you would need both priors. It's
because
just
the ones outside the 7.
correct.
Gotcha.
And there is a mistake on the complaint. It says April 25th of 2002, and I believe it was in February of 2002.
2000.
2000, I'm sorry.
February of 2000.
2000, yeah.
Did you also have an operating while impaired conviction at that time?
That was that at that
Yes.
time. Yes.
Oh, so 2 prior alcohol related driving offenses?
Yes.
Okay, with that, Mr. Ziegler,
I'm satisfied with the factual basis. Your Honor.
Mr. Vermetten.
As am I, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Vermetten.
Yes, sir.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Vermetten.
Yes, sir.
The court finds that the plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that Mr. Stevens is guilty of the additional charge of operating while intoxicated as a second offense. The court will accept the guilty plea. I am going to have this set for sentencing on a separate date, given the blood alcohol content, given that this did involve a collision with another vehicle. Is that correct?
That's correct. Your Honor.
That is correct.
So I think if nothing else, the court needs to give, under the Crime Victims' Rights Act, that person involved an opportunity to come to court and speak. I don't know, assuming there were no injuries based on the charge, but anyway, I don't think the court can proceed with sentencing on today's date. For those reasons, so we'll have it set. I am going to ask probation to prepare a misdemeanor PSI. So Mr. Stevens, you'll meet with Agent Bear up here before you leave today to set the date to do that. And then the court will set this for sentencing and you'll be notified of the date and time of that along with Mr. Vermetten. So just make sure that you stay in touch with him prior to that date. Okay.
Thank you, Your Honor.
Thank you very much, Your Honor.
Thank you, Mr. Stevens.
See you.
Mr. Seeger, were you ready with your next case? or-
Yes, Your Honor.
You were? Okay. This way. Is that Miss Way?
Yes, Your Honor, she's lodged. And Your Honor, I'm not sure if Miss Hillary is back. Well, I guess she's by Zoom. Never mind.
Yeah, they were talking about that.
This way, if you can come right up to the podium there, please. Go on the record in People versus Amanda Way. This is case number 244958. The record should reflect that Miss Way is present here in the courtroom. This is the date and time set for sentencing in this matter. And Ms. Way, have you had a chance to go through the pre-sentence report? Okay. Have you had a chance to talk to Mr. Seeger about that? Mr. Seeger, are there any additions, deletions, or corrections?
No, Your Honor.
Are there any challenges to the scoring?
No, Your Honor.
Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people by way of allocation?
Your Honor, I would adopt the recommendations contained in the PSI. I think given this Way's relatively minimal history for what we typically see in this court, the recommendation for probation is appropriate. She's already served 92 days jail. I think that in a vacuum would have been an adequate sentence with a probation term to address this. So I would adopt the recommendations contained in the PSI, Your Honor. Ask the court to sentence her to 92 days with credit for 92 days. place her on a probation for a period of time. And hopefully, much like the last defendant, she can get her substance abuse issues under control.
Thank you, Mr. Seeger.
Likewise, Your Honor, I would just ask the court to generally follow the recommendation. This case is similar to the last case, and as much as he's a person who continues to have a control substance problem. Speaking with Ms. Way, she had indicated, and she looks much better today than she did when I originally had met her. And she's had a period of sobriety, and I think that hopefully going forward, she won't have some like problems. She had expressed to me that she wants to remain sober, that she would successfully get through her probation. So I'm taking her at her word at that, and hoping that she's able to correct some of the problems.
Thank you. Ms. Way, anything that you wanted to say?
Just that I'm ready to move forward with my sobriety and stay sober. I owe it to myself to be recovered. And I'm ready, I'm over it.
All right, I did read through the report, so I'm familiar with what happened in this case. I'm also familiar with your background and your circumstances based on the information in that report. Taking that into account, along with what the lawyers have had to say and yourself here today, I do think the recommendation is appropriate. I think a term of probation where you're kind of being under the court's thumb a little bit to make sure that you're being monitored, that you're staying clean, that you're testing. I think that's going to help you as you move forward to know that there's that supervision. I do think that you served an adequate penalty in terms of jail time at this point. And so the court is not going to order that you serve any additional jail time. However, if you don't comply with probation, you may be subject to additional penalties. So there's a consequence if you don't follow through with the probation. The upside of that, of course, is that you're going to stay clean and hopefully do better. So the court is going to adopt the recommendation and sentence you to probation for a period of 12 months. The court is going to adopt as the conditions of your probation all the terms and conditions listed in the report. And that, of course, includes that you not use or possess any controlled substances unless they're prescribed to you. Also, that you not be with anybody who's using. Most people, that's going to help you as well going forward. The court is going to order that you serve 92 days in the Kalkaska County Jail. You do have credit for 92 days served. Crime victims assessment of $130, $30 per month supervision fee while you're on probation. Court costs of $325, attorney fees of $350, $60 DNA testing fee, and a $68 state cost. You do have the ability to seek an appeal of this sentence and start it.
Your Honor, for the record, returning a copy of the call rights.
Once we get someone.
Okay.
Anything further, Mr. Seeger?
No, Your Honor.
Mr. Ziegler? Good luck to you going forward. Ms. White.
Thank you.
Man, and Your Honor, I know we're a little bit early, and I do have a docket with Ms. Hill today. In any event, I did ask Mr. Gooding to log in, which should be hopefully a simple plea.
Yep, I do see him here in the waiting room. Here it is. All right, sir, is your name Dylan Gooding?
Yes, Your Honor.
Okay. All right, we're on the record in People versus Gooding. This is case number 244947. The record should reflect Mr. Gooding's present today by Zoom video by prior approval of the court. And Mr. Seeger, you indicated that we do have a resolution, is that correct?
Yes, Your Honor. Your Honor, it's my understanding that Mr. Gooding is going to plead to an added count of attempted resisting and obstructing, and the balance would be dismissed. Additionally, Your Honor, my understanding is that people have no objection to court costs and fines in this matter.
All right, Mr. Ziegler.
Fair statement, Your Honor.
Mr. Gooding, were you able to hear what Mr. Seeger said about the plea agreement?
Yes, Your Honor.
Have you discussed that exact agreement with him prior to today?
Yes, Your Honor.
Do you need any more time to discuss it with him, or did you want to move forward with that agreement?
No, I'd like to move forward with it.
You raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Gooding, are you currently on any probation or parole?
No.
All right, and you understand that the maximum possible penalty you could face for attempted resisting or obstructing is up to 1 year?
Yes, Your Honor.
With that maximum possible penalty in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty today?
No, they have not.
Has anyone promised you anything other than what we said here on the record today?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
The information I have indicates this happened on July 5th of 2024. Is that the correct date?
Yes, Your Honor.
On that date, were you present here in Kalkaska County?
Yes.
Right, and while you were here in Kalkaska County, did you come into contact with some Michigan State Police troopers?
Yes, Your Honor.
Did they have their uniforms on?
Yes, they did.
Did you know that they were there acting as police officers at that time?
Yes, Your Honor.
Okay, and what did you do to attempt to resist or obstruct those officers?
I started to run for a short bit of time and then ultimately stopped running.
Okay, and that was contrary. Was that contrary to some orders that they gave you? They wanted you to remain where you were at?
Yes, Your Honor.
Okay. Mr. Ziegler, are the people satisfied with the factual basis?
And
Mr. Seeger?
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
there you are.
Mr. Seeger?
No, sir.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of its plea?
Yes, sir.
Mr. Seeger?
Yes, sir.
Mr. Gooding, the court finds that your plea is knowing, voluntary, and accurate. Court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. In terms of sentencing, Mr. Ziegler, do the people have any objection with going forward with sentencing?
There you go.
It doesn't sound like there was any physical resistance to
No,
the
Your Honor.
officers. Okay. And Mr. Seeger, have you talked about that with Mr.?
I have, Your Honor. I told him that it may be possible, but it's entirely up to the court.
Mr. Gooding, you understand that you have the right to have a sentencing hearing at a later date,
Yes, Your Honor.
and that you have the right to have that hearing in person when you're here in the courtroom along with the lawyers and myself.
Yes, Your Honor.
You can waive that right and we can go forward with sentencing today. Did you want to waive that right?
Yes, Your Honor.
Is that something that you've had a chance to talk to your attorney, Mr. Seeger, about?
Yes, Your Honor.
You need to discuss that with him any further before we go forward.
No, I do not.
Mr. Ziegler, what's the people's position regarding the sentencing here and allocution?
Your Honor, this is a circumstance, this was back on or about the 4th of July of this year. Mr. Gooding was here in Kalkaska County, he's a resident of Illinois. It's my understanding, based on the report, that he got into an altercation with a family member of his. They were having some fun with some fireworks, somebody got hit in the face with a firework. An argument ensued, the police were called. When the police arrived, the defendant decided to run from law enforcement. He was given several commands to stop running. They pursued him and he tripped over a tree branch or a root or something to that effect and fell down. Officers subdued him at that time and he didn't offer any further resistance. Given those facts, Your Honor, and also given the fact that his criminal history is minimal, I think he may have 1 or 2 traffic issues out of Illinois, nothing out of the state of Michigan. It would be my belief that court costs and fines are appropriate to address this matter. I'm assuming that Mr. Gooding has learned a valuable lesson out of this incident. It's unlikely to recur. And in terms of the assault, the underlying assault that caused the officers to arrive, the victim had stated at the time that he didn't want any charges to arise out of that incident. So there's no issues with concerns for the victim or the victim's safety or the victim's issues with proceeding in this manner. So for those reasons, Your Honor, given the pro forma nature of the resist and obstruct, where it was merely a failure to follow lawful commands that ultimately resulted in no injuries or anything like that, I would ask the court to simply impose court costs and fines.
Thank you, Mr. Seeger.
I can't really say much better. That's generally pretty much what happened. So clearly it was a bad decision that he made, and clearly he shouldn't have run. It would have just been easy to stay there and follow the lawful command. But I think the greater penalty for him now is that he has this on his record, and that, I guess, I'm not sure what the rules and regulations are in Illinois, but it certainly would affect him should he engage in somewhat like behavior going forward in the state of Michigan.
All right, did Mr. Gooding serve any time up front after the arrest on this?
Your Honor, I believe he would have bonded out at the time of the arraignment, so I would assume if he. He was arrested on the 5th and he was arraigned on the 5th, so he didn't have 1 day of credit there.
All right, Mr. Gooding, is there anything you wanted to say today?
No, Your Honor. I mean, I guess I could say I've learned my lesson, and ultimately I should have listened to the commands and not ran at that time.
All right, thank you. So first of all, you know, the court has a couple, excuse me, ma'am, we're in the middle of court here. Thank you. The court has a number of different ways that it can punish wrongful conduct. The most obvious way, of course, is jail time, taking away your freedom for a period of time so that you understand there are consequences to behavior like this. The other way is the court can punish is financially through the pocketbook. Based on what the attorneys are telling me in terms of the facts of this case, I think, and given your lack of a previous criminal history, the court finds that a financial penalty is sufficient at this point to impress upon you the wrongfulness of your actions in this case, and so that you understand there's a consequence for that. Certainly, when police officers are responding to a situation like that, they're trying to figure out what's going on. It sounds like it was probably late at night. I'm sure there were alcohol or other substances involved. And that's a circumstance where they really just need to find out what's going on. And when somebody takes off running, that makes it much more difficult for them to determine that. And it also heightens everyone's perception of what might be going on. When somebody runs, it makes police think that they're running for a reason, and that gives them concerns too, and makes the entire situation more dangerous for everybody. So I hope that you have learned your lesson. And I hope that we don't see you here again in Kalkaska County for this kind of reason. So the court is going to follow the recommendation. The court is going to sentence you to a $50 state cost, the $75 crime victims assessment, $325 in court costs. Mr. Seeger, are you appointed in this case?
I was, Your Honor.
An attorney fee of $350. And as I said, as a penalty in this case, the court is going to impose a fine of $500. You do have the ability to seek an appeal of this sentence. Because this is a misdemeanor, you aren't going to get any written appellate rights, but if you wanted to appeal this sentence, you would need to file that paperwork within the next 21 days. If you have any questions about that, I'm sure Mr. Seeger would be happy to answer those questions for you after the hearing today. Otherwise, once we disconnect, you need to make sure that you call the clerk's office here in Kalkaska County to make arrangements to pay those fines and costs. If you fail to do that, a bench warrant may be issued for your arrest and you may be brought here to Kalkaska County and lodged in the jail until we can make arrangements for that. Do you have any questions about that?
No, Your Honor.
Okay, Mr. Seeger, anything further we need to address today?
No, sir.
Mr. Ziegler?
No, Your Honor.
Okay, thank you, Mr. Gooding. Good luck to you going forward, and you're free to disconnect at this time.
Thank you, Your Honor.
All right. And then Mr. Seeger, you have Ms. Hiller's case too?
I do, Your Honor. She's lodged in Wexford County.
Okay.
And then the only other matter I have, Your Honor, is the resentencing.
All right, let's take a short recess. We'll come back on the record in about 5 minutes.
All rise.
Mr. Seeger, we still don't have anybody signed in.
Oh, yeah, that's fine, Your Honor. I thought you went to look at Smith, Your Honor. That's the only reason I stayed.
Thank you. And I did have a chance, so let's go back on the record. Okay, this is People versus Ford Smith, case number 244896. Again, if I can.
Brian Ziegler, on behalf of the people, Your Honor.
Thomas Seeger, appearing on behalf of Mr. Smith.
All right, I did have a chance to take a look at that, given that the court is not imposing any additional jail time, and Mr. Smith has not appeared today. Or can move forward with the sentencing hearing, even in his absence. The court would also have the option of issuing a bench warrant for his arrest, of course, and having him brought to court. I don't think that that's really an appropriate solution here, given that he served well in excess of the statutory maximum. And so the only point of that would be basically to inform him of the fines and costs, which we can do in other ways. So, Mr. Ziegler, do the people have any objection to the court proceeding with this hearing today?
There you are.
Mr. Seeger?
No objection, Your Honor.
Okay. Mr. Ziegler, anything on behalf of the people today in terms of sentencing?
Yeah, the court's already aware of the relevant facts. Mr. Smith was found guilty of assault and battery at trial, 93-day max. He served 222 days of jail on the felony charge, which he was acquitted of at trial. For those reasons, I don't see the need for the court to have him present or to do anything other than to sentence him to the 93 days in jail with credit for in excess of 93 days and impose whatever court costs and other obligations are required by statute.
Thank you, Mr. Seeger.
Your Honor, likewise, I would just ask the court to make the court costs and fines, and there's probably really not a whole lot the court can do because he's already beyond the 93 days that the court could have imposed. So I assume that any court costs and fines are reduced for collections to the extent that he doesn't pay it.
All right, the court's familiar with the facts of this case based on the jury trial that was held in September. The court is going to, because this was a misdemeanor conviction, the court's going to impose a $50 state cost, a $75 crime victims assessment, court costs of $325, and attorney fees of $350. The court will order that Mr. Smith serve 93 days in the Kalkaska County Jail. He does have credit for 93 days served. The court will have the narrative portion of the judgment of sentence reflect that he did actually serve 222 days of jail time. And then the court, along with that judgment of sentence, will forward but the court's going to forward written appellate rights to Mr. Smith since he's not present to his last known address. Mr. Seeger, anything further today?
No, Your Honor.
No, you're on.
Okay, thank you. People versus Sarah Lee Marie Elzel, case number 234824. Also present.
She is not, Your Honor.
Okay. She's not lodged here now.
She is not, Your Honor. My understanding is telling Mr. Ziegler is I got a text from her significant other at about 8 o'clock this morning that she was in Munson Medical Center. He had found her last night collapsed, and according to the text, they took her to the hospital. She had a heart attack and are actually hoping to do surgery sometime in the near future. Your Honor may recall, we actually adjourned this sentencing for 2 months because she was supposed to get heart surgery. She, when I spoke to her recently in the lead up to the sentencing, ended up with an infection, and they were not able to do that surgery as planned. And we were going to let the court know that it still needs to be done, but it had not been scheduled because apparently she had not cleared up enough from the infection enough for them to schedule it. So I don't have any documentation from the hospital, but hopefully we'll get that. But I do know she has had some pretty serious heart issues this past period, and unfortunately, it looks like last night things did not go well.
Mr. Ziegler.
Yeah, I know this case is dragged out for quite some time, but I think especially given the fact that the prior adjournment was due to a hard issue. I don't have any reason to doubt what defense counsel is telling the court today. I would ask the court to set this out for another sentencing date and order that Ms. Household provide at that time of that next date, whatever documentation she has to support the claims of Mr. Travis here today. And hopefully we can get that resolved in the near future. She makes a recovery.
All right, the court notes that the PSI does reflect that she does have heart issues. The court is going to set this for a show cause and sentencing hearing at the court's next available date. And Mr. Travis, as Mr. Ziegler indicated, if you can have Ms. Helsel provide to the court or either directly or through you some confirmation of her medical condition that prevented her from being here today.
Thank you.
Okay. People versus Hiddle, case number 234859.
All right, Mr. Hiddle is not here. I've been looking out for him. Not see him outside. Unfortunately, I have a number of phone numbers for Mr. Hiddle, but none of them were working in the past few days, and I've tried to get a hold of him.
Your Honor, this likewise is a fairly old case. Mr. Hiddle has a remarkable track record of failing to appear over the course of many years on this file. I would ask the court to issue a bench warrant for his arrest with no bond.
Yeah, just looking at the file, it looks like we've had repeated issues with Mr. Hiddle. So the court will issue a bench warrant. The court will order that his bond be revoked and that he be held without bond once he's arrested in the Kalkaska County Jail. Once he is arrested, the court will set it for a bond hearing and status conference at its next date following his arrest. Okay. People versus Evans, case number 44967.
Yes, Your Honor. Kyle Travis on behalf of Mr. Evans, who is present in the courtroom.
Can you tell me the status of this file?
Yes, Your Honor. Your Honor, Mr. Evans waived the preliminary exam in this matter based on an offer to handle the matter under 7411. It is my understanding it's a count of possession of narcotics, a 4-year with no enhancements or other charges. So the prosecutor's offer, my understanding, is to plead to that count under 7411, and that is what Mr. Evans would like to do.
Okay, Mr. Ziegler, is that the correct statement?
It is, Your Honor.
Okay. Mr. Evans, have you had a chance to talk to Mr. Travis about this agreement?
Yeah.
Okay. And, has he explained to you what 7411 means and what the advantages are for you and the disadvantages of that?
Yes, sir.
Okay. Is that how you want to proceed today?
Absolutely.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
Thank you. Mr. Evans, are you currently on any kind of probation or parole?
No.
Have you ever had a controlled substance related offense in the past?
No.
All right, and you understand that if you were to fail to successfully complete your probation, the maximum possible penalty you could face would be up to 4 years and or a $25,000 fine.
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
I'd like to take the 7411, but I mean, I'm guilty as, I got caught and, it saved my life. It was probably one of the best days of my life. So, I'm never going back to that period. It's in the past and.
You're gonna plead guilty.
Yeah, yes, Your Honor.
Okay. And you'll have a chance at the sentencing hearing to tell me all those kind of things that you think are relevant.
Okay.
Okay. So I'm gonna go through your rights with you.
Your Honor, he did fill it, and this one is, I think, a misdemeanor advice rights, so it's close but not exact.
Yeah, and that's good. I'm still required to have that colloquy with them under the court rules directly. So Mr. Evans, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witness against you appear at a trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at a trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand that you have all those rights?
Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask for the next higher court up, which is the Court of Appeals, to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to plead guilty?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
Okay, so this happened back on August 31st of this year, is that correct?
Correct.
And on that date, were you here in Kalkaska County?
I was, yes.
And while you were here in Kalkaska County on that date, did you have possession of some fentanyl?
Yes, I did, Your Honor.
Did you know that that's what that was?
It was an old piece of tinfoil that was in my wallet. I did not know it was in there, but I'm sure lucky it was, so.
Okay.
Yeah.
Where did you get that piece of tinfoil?
Probably from my kitchen, probably my kitchen.
Okay.
It
Were there drugs on, was there fentanyl on that?
Yes, sir.
Tinfoil? Okay.
Yes, Your Honor.
All right. Mr. Ziegler, are the people satisfied with the factual basis?
Mr. Evans, do you remember telling law enforcement that you thought that substance was cocaine?
I do.
So you believed it was a controlled substance?
Yes, sir.
I'm satisfied, Your Honor.
Oh, Mr. Travis.
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis.
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Travis.
Yes, Your Honor.
Mr. Evans, the court finds that your plea is knowing, voluntary, and accurate. Court is satisfied there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. You're going to meet with Agent Barup today before you leave the courthouse to set up a pre-sentence interview. And then the court will set this for the sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Travis prior to that date, okay?
Absolutely.
All right,
Thank you.
Mr. Evans. Mr. Travis, did you have any other files today?
I don't believe so.
Is Ms. Hiller present? Mr. Hiller? Our next hearing set for 10:45. We'll take a short recess until that time. Mr. Isles, were you ready with Mr. Komai?
I am not his attorney, Your Honor. I was subbed out. Once ago.
Okay.
Mr.
Vermetten?
Is here.
Okay.
Yes.
Oh, I'll change that.
I'm not sure how that all worked out, Your Honor, but we keep getting each other's mail, so nice to get reacquainted with Mr. Isles, of course.
Can you just make a note?
Yeah, I'm changing it right now.
Okay, great. All right, sorry about that, counsel. Can you put your appearances on?
Ryan Ziegler, yeah, people, Your Honor.
On behalf of the defendant, Matthew Vermetten.
Okay, and this is People versus Komai, case number 244971. Mr. Vermetten, can you tell me the status of this file?
I can, Your Honor. There was a 5-count felony complaint filed by Mr. Ziegler's office. After much negotiation and discussion, Mr. Ziegler has agreed to dismissal of counts 1, 2, 3, 4, and 5 with an additional count 6 of third-degree home invasion on a delayed sentence.
Mr. Ziegler?
That's a fair statement, Your Honor, and upon successful completion of that delay, the charge would be reduced to a entry without owner's permission under 750-115.
Okay, what's the maximum penalty for their?
Your Honor, I believe it's a 5-year felony.
Okay, Mr. Komai, have you had a chance to talk to Mr. Vermetten about this plea agreement?
Yes.
Okay, and you need any more time to do that before we go forward here today?
No, sir.
Okay, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Komai, are you currently on any kind of probation or parole?
No.
And as Mr. Ziegler indicated, you understand that if you were to fail to successfully complete this delay of sentence that's being recommended, the maximum penalty you could face would be up to 5 years in prison.
Yes, sir.
With that in mind, what is your plea to that charge today?
Guilty.
Okay. Right now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
I do.
You understand that you're giving up and waiving all of those rights by pleading guilty?
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask the next higher court up, which is the Court of Appeals, to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
I do.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are guilty?
Yes.
Okay. The information I have indicates this happened back on June 20th of 2024. Is that the correct date?
Yes, sir.
And on that date, did you enter into a home at 14 Anderson Road here in Kalkaska County?
I did.
Did you have any permission to go into that home?
No.
And while you were, when you went into that home, did you have a pistol with you?
No.
No? Okay. Mr. Vermetten, can you ask some questions? I don't know what the factual under.
Certainly.
Yeah.
And I'm certain, yes. Did you enter the dwelling without permission of the individual who was in the dwelling?
Yes.
Were you there to confront the individual who was in that dwelling?
I went there to talk to him.
All right. At some point when you broke the curtilage of that dwelling, did something happen with that individual? An altercation?
Yes.
All right, and then you exited the dwelling, correct?
Yes.
I'm satisfied there's a factual basis to the home invasion third degree, Your Honor.
Okay. Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Burnett?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Burnett?
The court has.
Mr. Comine, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Burnett prior to that. Also, before you leave today, you're going to meet with Agent Vera to set up a pre-sentence investigation report. Do you have any questions at all?
No, sir.
I'm sorry, is there a
Thank you very
PAC
much.
code or a notice code?
750-110. A is an Adam 4.
Thank you.
The PAC code is different. than-
Pat code,
Yeah,
okay,
it's
all
different
right,
than the statutory citation.
very good. Nice to see you again, Your Honor.
You too. Been a while.
Yeah, it has, indeed.
Mr. Williams, are you able to hear me okay?
Yes, Your Honor, thank you.
Okay, we're on the record in People versus Hunter Owens. This is case number 244948. Record should reflect that Mr. Williams is present by Zoom video along with his client by prior approval of the court. We have Mr. Ziegler present here in the courtroom. This is set for a status conference today. Mr. Williams, from the defense perspective, can you tell me the status of this file?
Yes, Your Honor. Sorry, my computer's trying to update while we're talking. The people are generously allowing him to plead to a 93-day misdemeanor. Part of the deal was he'd pay back the restitution. It was about little over 16,000. He will have that paid off by the end of November. Is that correct, Hunter?
Yes, yep.
So I don't know if you guys are comfortable putting a plea on today, or if you prefer to just set it for a plea and get the rest of that paid off. And then, you know, it's going from a felony down to a 93-day misdemeanor. He's a young person, made a mistake in business. I'm open to whatever the parties are amenable to. I could get a plea established, or we could set it for a plea and he could finish paying that balance. It's around 3,000, and then we could do a plea then, whatever the people would prefer, I guess.
Thank you, Mr. Ziegler.
Your Honor, I'm comfortable taking the plea so long as the restitution is paid at or before the time of sentencing. And if not, we would have a right to ask for withdrawal.
Okay, Mr. Williams, do you have any objection to proceeding that way?
I don't. Mr. Owens has got a lot going on. He's done a really good job paying it back. It's almost paid. He will have it paid. If we could set maybe sentencing out in December sometime, so it is paid, that we would like to do that if we could.
Okay. Mr. Ziegler, can you tell me the misdemeanor in the PAC code that the plea will be entered to?
Your Honor, the misdemeanor would be to a non-sufficient funds check less than $100. It's a 93-day misdemeanor. PAC code is 750.1313A1.
Okay, thank you. Mr. Owens, have you been able to hear everything that the lawyers have said here today?
Yes, Your Honor.
Is that the plea agreement that you've discussed with Mr. Williams?
Yes, sir. Yep.
Is that how you want to proceed today?
It is, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Owens, are you currently on any kind of probation or parole?
No, just bond with the court originally.
Okay, and you understand that the maximum possible penalty you could face here would be up to 93 days in jail?
Yeah.
With that in mind, what is your plea to that charge today?
Jesse, just guilty,
Correct.
guilty, Your
I
Honor.
could establish a factual basis if you want, Your Honor.
Okay, as soon as I go through his rights, then I will give you the opportunity to do that. Mr. Owens, I'm going to go through your rights with you. You do have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf to appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. You understand all those rights.
I do, Your Honor. Yep.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir. Yep.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here on the record today?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
Thank you. Mr. Williams, if you would like to conduct some questioning of your client to establish the factual basis.
Mr. Owens, isn't it true that in Kalkaska County, you did write a check to a certain party that was in the excess of $16,000?
It was two separate checks, but yes.
Totaling 16,000. Thank you.
Yes. Yeah.
And isn't it also true that after you wrote those checks, you spent the money in the account knowing that those checks would not clear?
Yeah.
And that was here in Kalkaska County?
The checks were written to the party who lived in Kalkaska County. Yes. Yep.
Thank you.
All right, thank you. Mr. Ziegler, are you satisfied with the factual basis?
I am, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Williams, are you aware of any?
No, Your Honor, none.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Williams, are you?
Yes, Your Honor.
Thank you. Mr. Owens, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. The court will set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Mr. Williams, can you contact the probation department with contact information for Mr. Owens so that they can get in touch with him for a pre-sentence report?
I will, Your Honor. Yes.
Okay. Mr. Williams, anything further from your side today?
Nothing, Your Honor.
Mr. Ziegler?
No, Your Honor.
Okay. All right. Thank you. That's all for today. And you're both free to disconnect at this time.
Thank you.
Thank
All
you.
right. Bye.
Mr. May here.
Yes, Your Honor.
We'll go on the record in People versus Thomas May. This is case number 234826. Record should reflect that Mr. May is present here in the courtroom. If I could have counsel put your appearances on.
Ryan Ziegler, on behalf of the people, Your Honor.
Scott Isles, we have Thomas.
All right, thank you. We are set for a probation violation hearing today. Mr. Isles, how does Mr. May want to proceed?
Your Honor, this was a 3-count violation. Count 1 has been dismissed because it was incorrectly filed. Count 2 is a domestic violence, which my client will not be pleading to. Count 3 is a driving while license suspended, which my client did do and would be pleading to. We are in the midst of negotiating on the domestic violence. I've made an offer. Unfortunately, I've had some personal issues. My sister died. She was taking care of my father, who was in Florida. I had to take over, and then he fell out of bed, and he was in the hospital, and he recently died. So I've been adjourning it down in district court because I've had to fly to Florida to deal with all of this, and it's taken more time than we expected. We're scheduled for a settlement conference on the 13th. And either we're going to work it out or we're going to set it for trial at that time. We would ask that this matter be adjourned until we figure out what's happening in district court on that charge. And I've already talked to the prosecutor. I believe they're in agreement.
All right, Mr. Ziegler, Mr. Barrett.
Your Honor, the defense is willing to plead to the third count, but we have some disagreement about the second count. I don't think it makes sense to do it piecemeal, so I wouldn't oppose the request from the defense to adjourn the whole thing out until we know what's going to happen with the domestic violence in district court.
Okay, so I agree, since the violations are based on potential underlying other conduct, then we'll set this out for 90 days. And we'll go from there. And Mr. Isles, I remember you appeared for that one hearing by video from Florida. I'm sorry to hear about your family. It's a lot to deal with in a short period of time. So my condolences.
Thank you, Your Honor.
And that's all for today.
Thank you.
The court's going to call People versus Jennifer Hiller. That's case number 244956. I did receive information that Wexford, she's lodged in Wexford County is having internet issues and they're not going to be able to have her available. I'm going to notify Mr. Seeger of that, and then we're going to reset this matter for hearing at the court's next available date. Mr. Ziegler, any record you wanted to make in that regard?
No, Your Honor, I have no objection to that.
Okay, thank you. Our next hearing is set for 11:15. So we'll be in recess until that time. And we're on the record in People versus Peterson, case number 244933. If I could have counsel put your appearances on the record. I'm sorry, this is case number 244970.
Ryan Ziegler on behalf of People.
Jim, on behalf of Public Users.
Thank you. This looks like Mr. Peterson's first appearance in circuit court. Mr. Hunt, can you tell me the status of this file today?
Your Honor, we've already worked out an arrangement with the prosecutor. My client is going to be pleading as charged with consideration under HIDA.
Okay, thank you.
Great statement, Your Honor.
Okay. Mr. Peterson, have you had a chance to speak with Mr. Hunt about this agreement?
I have.
Okay, and what he said is that your understanding of how we were going to proceed today?
It is.
Okay. Do you need any more time to talk to him before we go forward?
I do not.
You raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
Thank you. Mr. Peterson, are you currently on any kind of probation or parole?
I am not.
And how old were you at the time of this incident?
19.
You understand that by pleading guilty to this count, which is fleeing and eluding a police officer third degree, if you were to unsuccessfully complete your probation, the maximum possible penalty you could face would be up to 5 years and or a $5,000 fine. Do you understand that?
I do.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask for the Court of Appeals to hear your case. If they said no, that would be the end of your appeal. Do you understand that?
I do.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here in court today?
No.
Is it your own free choice to enter this plea?
It is.
Are you pleading guilty because you are guilty?
Yes.
Okay. The information I have indicates this happened back on September 5th of this year. Is that the correct date?
Correct.
Okay. On that date, were you operating a motor vehicle here in Kalkaska County?
I was.
And did you come into contact with a deputy from Kalkaska County Sheriff's Department?
Yes.
And was that deputy driving a marked police car?
Yes.
Okay. And did he give you some kind of signal, either directly himself or through lights or sirens, that you were to pull over your vehicle?
Yes.
And did you fail to do that?
I did.
And in fact, did you try to get away from that officer?
I did.
Okay. Mr. Ziegler, are the people satisfied with the factual basis?
I am, Your Honor.
Mr. Hunt?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Hunt?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Hunt?
Yes, Your Honor.
Thank you. Mr. Peterson, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that in the interim that you stay in touch with your attorney, Mr. Hunt. You're going to meet with the probation department today before you leave the courthouse to set up an interview with them. Mr. Ziegler, anything further today?
No, Your Honor.
Mr. Hunt?
No, Your Honor.
Okay. Thank you. That's all for today.
Thank you, Mr. Peters.
Mr. Seeger, for the record, I don't know if anyone got in touch with you yet? Miss Hiller's case, Blacksburg County, their internet is down. They're not gonna be able to connect with her.
That's fine.
So we're gonna reset that for a hearing.
That's fine, Your Honor, and just for the record, she wanted me to file a bond motion, so maybe I could do that in between, and I did get some verification from ATS saying that they had that available to her. There are two files, and I don't remember if the other files in front of you, because one was recently filed over. So one might be in front of Judge Hunter, but I think they're both in front of you. I think I may have just gotten a notice for the second file.
Okay.
But I can file a motion and then maybe we can take it up at the next date and try and coordinate with Ms. O'Rourke.
Okay. Are you gonna be asking her to be released for treatment?
So she's generally asking me to ask the court to see if you would allow her to be released into treatment. I mean, whatever it is that we do with her files. The other compliment or problem that she has is she's currently on parole, for which the Department of Corrections would have to, I'm not sure how it would work, but theoretically, once she's on bond, she's available to the Department of Corrections, so that's another complication, but she asked me to ask, so I said that I would, and I was going to ask.
Agent Barrett, did you?
No.
Or you look like you wanted to
Oh,
say
no,
something.
no,
Okay.
I mean, if she's granted bond, then, then doesn't mean she's getting out, doesn't.
Yeah, I did explain all those.
Yeah.
things.
Okay. Okay, I think, we have 11:15, Mr. Christie's resentencing. I don't see MDOC connected yet. So as soon as we get them connected, we'll proceed with that.
If you think it's gonna be a minute or two, I ask the judge to stop a hearing, but not that that's really your problem, but.
No, we can, I can let them know until you're ready.
Okay, maybe I could try and take care of this then.
Yes.
Right.
Yep, thank you. Okay, we'll be in recess until 11:45. Or until Department of Corrections connects. Okay, we're on the record in, excuse me, People versus Justin Griffer, case number 244915. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Good morning, Your Honor. Lauren Kreinbrink representing Mr. Justin Griffer, who is present and seated to my left.
Okay, counsel, if you and your client want to come up to the podium, please.
Yes, Your Honor.
This is the date and time set for sentencing in this matter. Mr. Griffer, have you had an opportunity to go through the pre-sentence report and speak with your attorney about that?
Yes, Your Honor.
And counsel, are there any additions, deletions, or corrections to that report?
Yes, Your Honor, just a few minor corrections.
Okay.
The first would be the sentencing date on page 1. We would just ask that that reflects today's date.
Okay.
As opposed to October 8th.
All right.
And then as for the plea agreement, Your Honor, we would just ask that that section contains additional language indicating that the prosecution also agrees not to issue any charges stemming from the cocaine that was found in my client's on my client's person.
Okay, Mr. Ziegler.
That's fine.
Okay, we'll make that addition. Any other changes to the PSI?
Your Honor, on page 3, this would just be a minor addition that we would ask for. Under the section, or excuse me, the second paragraph that starts once the defendant. The last sentence indicates that the drugs were confirmed to be methamphetamine and cocaine by a true narc test. We would just ask that that also reflect this was confirmed by the Michigan State Police Crime Lab as well.
Okay. Any objection to that addition?
No, Your Honor.
Okay, we'll make that addition. Any other changes?
No other changes, corrections, or additions, Your Honor. Thank you.
Okay, are there any challenges to the scoring?
No, Your Honor.
Okay, Mr. Ziegler, do the people have any additions, deletions, or corrections?
Your Honor, I think the only thing that needs to be changed would be the jail credit. I think those 69 days reflect from October 8th. Case barricades are 97 days would be the new total jail credit, Your Honor.
Okay, Ms. Kreinbrink, any objection to that?
No, Your Honor. Thank you.
Okay. All right, any challenges to the scoring, Mr. Ziegler?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, the defendant is before you for his pleas to fleeing and eluding, carrying a concealed weapon, possession of meth. These will be the defendant's 6th, 7th, and 8th felony convictions. I want to take some time to impress upon the court the seriousness of the defendant's course of conduct in this case. Sergeant Beaver had observed the defendant's vehicle driving in a suspicious manner, where the defendant's vehicle then proceeded to drive through a ditch and to flee Sergeant Beaver. Sergeant Beaver turned on his lights and pursued. Once he was able to effectuate a stop, which was at the defendant's residence, the defendant refused to comply with commands. Once cuffed, the officers found a pipe and ammunition on his person. The defendant continued to physically resist officers. At one point charged at officers while asking to be shot. Further searching of the vehicle led to the discovery of a taser and several small baggies of controlled substances, which totaled approximately 12.5 grams of meth and 3 grams of cocaine. The defendant has a lengthy criminal history. It includes a prior prison sanction from 2007. His history includes convictions for things such as unlawful driving away, unlawful use, attempted forgery, fleeing and eluding, and some other traffic offenses. His record, Your Honor, while certainly not the worst record to come before Your Honor on a case like this, it does not recommend him well to a community sanction in this case. Given the significance of the conduct at issue in this matter, given the defendant's record and other factors that are not particularly mitigating, the people would support the recommendation for a prison sanction in this case, Your Honor. The guidelines are 10 to 23. The people do not see any good reason to sentence the defendant on the lower end of that guidelines range. The possession was of a fairly large quantity of drugs. He was armed and he fled and resisted law enforcement. The sentence of 18 months is reasonable, Your Honor, both to punish the defendant for his actions and to deter others from engaging in similar behaviors.
All right, thank you. Ms. Kreinbrink, anything on behalf of your client for allocation?
Yes, Your Honor, thank you. Your Honor, looking at the totality of the circumstances in this case, Mr. Griffer notably has a reputation in this county. He does have a criminal history, and that's something that we're not shying away from today. But setting aside Mr. Griffer's reputation, we would ask the court respectfully to look at the facts of this case. And this is not a case, from our perception, where we have a gun-toting drug dealer swindling drugs around Kalkaska County. In fact, Mr. Griffer has no prior drug convictions on his record and would be eligible for treatment pursuant to Section 7411 if the court would allow. Mr. Griffer stands before the court today extremely remorseful for his actions. And throughout the months that I've come to know him, we've had, I would say, long and complicated conversations about this case. And for the first time in his life, and he is still young, he presents at 34 years of age, he has indicated repeatedly that this case has been a wake-up call for him. And he recognizes that he does struggle with addiction. And I think that's something that a prison sentence in this case will not change, respectfully. Looking at the goals of punishment, I mean, certainly to deter others from committing similar acts, we believe that a county sentence would be appropriate and tailored to that. Certainly if the people have concerns, and I think they would in this case, about an individual with substances like methamphetamine and cocaine on the streets, a county sentence essentially would alleviate those concerns. But looking at the additional issue of rehabilitation, Mr. Griffer has never availed himself of treatment before. And he has started counseling, and he's indicated that's been productive for him. In addition, prior to today's hearing, he's found eligibility at Harbor Hall. And depending on how the court, again, sentences today, that's something that he would like to pursue. And for his first time in his life, he's indicated an interest in pursuing treatment. In addition to this case, Your Honor, Mr. Griffer is currently in the middle of a custody battle involving his young son, and he wants to be an example for his son. He wants to live a sober and productive lifestyle. And again, this case, I think, has truly given him the insight that he hasn't had before, that he can't continue on his path. So I don't think in any way or shape or form he's not willing to take responsibility. He is, but we would just ask the court to tailor a sentence to the facts of the case and to impose a county sentence that would allow Mr. Griffer to continue utilizing the resources he's availed himself to thus far, and potentially allow him to receive the treatment that he seeks.
All right, thank you. Mr. Griffer, anything that you wanted to say
Yes, Your Honor. Sorry, I'm really nervous. I want to start by apologizing for my tardiness at my last sentencing date. I know that when I came in for jury status and when I pled guilty to these crimes, that you had advised me that even though I don't have my license, that I need to account for that. And I thought I had done so, but I was late, and I've been lodged at the Wexford County Jail since October 8th. I wasn't attempting to avoid the sentencing. I was late, I was tardy, and now I'm here, I'm on time. And like my attorney said, in a lot of ways, the things I've experienced this year have been a blessing to me, because I wasn't doing very well, especially after not being able to see my son. And that could have gone even worse if I hadn't been arrested for these crimes.
Sorry, like I said, I'm really nervous. I've been struggling with the addiction, and I went to prison when I was quite young, and the effects from that, mentally, they didn't really start to affect me negatively for several years after I was out of prison, and I was in denial of what was going on. And then I started to use heavy drugs, and I've struggled on and off with that. And then I never sought treatment because I didn't really think I was having a problem. And this kind of, it was a massive eye opener, and it forced my hand into viewing my life and what's been going on, and how I was falling into a really bad downward spiral. And I got some approval for a bed in treatment, and where I'll be able to see a counselor and or multiple counselors, which I know I need that regardless of what I get sentenced to today. I want to get treatment before I return back home, so that I will have the tools that are necessary for me to not continue on the path that I was on. Because I do want to be there for my son. I want to be a good influence for him. And also there's the firearm. I'm thankful that I don't have to worry about having that anymore. I worried a lot that it was going to get stolen and used to do bad things, and now I don't have to worry about that, and it takes a massive weight off of my shoulders. And I know that I need help, and I need some tools for me to succeed in the future. And I know that the Harbor Hall is a really respectable place. They do really good work from everything I've heard. They help give people the tools that are necessary for rehabilitation, and I just ask that I get the opportunity to do that. Sorry, I'm really nervous, and I take responsibility for my actions. I know that what I was doing wasn't right, and I don't want to do those things anymore. I don't want to put myself in that position anymore for my future. I know I'm still young, and I got a lot that I could build my life on, and I want to be able to do that for myself and for my son. Thank you.
Mr. Griffer, I did read through the pre-sentence report, so I'm familiar with the circumstances in addition to what the attorneys have said about what happened in this case. I'm also familiar with your background based on the information in that report. And I take all of that into consideration, along with what each of the lawyers have had to say, and of course, what you had to say here today as well. You know, I understand about the last sentencing hearing. You did appear later that day, so I mean, I'm satisfied that you weren't trying to avoid the hearing. I'm sure something happened that prevented you from being here on time, so the court's not going to impose any kind of additional penalty for that, because you were here that day. It just was after your attorney had left, so we couldn't go through with the hearing. Outside of that, you know, the lawyers are correct about the court's job at sentencing. Part of it is punishment and deterrence. So number one, so that you're punished for your wrongful conduct. You know there's a consequence to behaving in this way. Also deterrence, so that the community can see that this is not acceptable. And that if others are thinking about engaging in this kind of activity, if they see that there's a serious consequence for that, hopefully they'll make different choices. And then, of course, rehabilitation is certainly part of it as well. And in your case, I agree. I think you need some help with your substance use disorder. Looking at the report, there's been some attempts at some inpatient and outpatient treatment in the past that obviously hasn't worked. I'm glad to hear you say that this is something you're going to pursue regardless of the court sentence in this case, and that's true. And I'm always a little bit surprised that people wait for a court to force them to go to treatment when they're free to seek that at any time. So there's no reason why you can't seek that out, and I think that you need it. Looking at the punishment and deterrence factor, that what you did here was really serious conduct, and everybody's lucky that this didn't turn out worse than it could have. You're combining substances, and fairly large amounts of those substances, maybe not the cocaine, but certainly the methamphetamine is 12 grams is enough of that. That's personal use. You had a heck of a stock. To me, that indicates potential sales or trafficking, probably to support your own habit, possibly. But significant amounts of substances with ammunition, weapons, and then, of course, your actions in fleeing from the police put that officer in danger. Those are all the types of conduct, especially by someone who has a prior felony, who shouldn't have any of those things in their possession, deserves punishment, and the court has an obligation to sentence you to provide a deterrent effect, because that is kind of, it's just not acceptable in our community. So when I balance those two things, given your past history between your juvenile record and adult record, you've been given numerous opportunities at probation in the past. The court has to weigh more heavily on the side of the punishment and deterrence in this case, given the seriousness of your conduct and the potential danger that you pose to yourself, to the community, especially the police officer that was involved. So for those reasons, the court finds that a prison sentence is warranted in this case, within the guidelines, but at the top end of the guidelines because of the seriousness of your conduct. As to the charge of fleeing and eluding, 4th degree, that has guidelines of 0 to 17 months. The court is going to sentence you to the Michigan Department of Corrections for a period of 16 months to 2 years, with credit for 97 days served and a $68 state cost. As the concealed weapons charge, guidelines are 10 to 23. The court sentences you to 23 months to 5 years in the Michigan Department of Corrections with a $68 state cost. The possession of methamphetamine charge, again, 10 to 23 months is the guidelines. The court sentences you to 23 months to 10 years in the Michigan Department of Corrections. As to that charge, a crime victim's assessment of $130, court costs of $325, and a $68 state cost. All of those sentences, again, to run concurrent to each other with credit of 97 days. You do have the ability to seek an appeal of this sentence, and if you can, officer, if you can hand crime brief, if you can have your client initial indicating that he's received those appellate rights, please.
Are there state minimum costs for each count?
Yes, $68. Yeah. Mr. Ziegler, was there something else we needed to address for the record?
Yes, Your Honor, on count 4, the carrying concealed, one of the mandatory penalties is mandatory forfeiture of the weapon or device involved. I would ask the court to include that.
Okay, the court will order that the weapon involved be forfeited. Griffer, you are remanded to the custody of the state.
Your Honor, we would just have one final question. I know the court's already imposed its sentence. Would the court have any consideration for boot camp for my client? Or I don't know if this conviction would render him ineligible.
Yeah, I don't think he'll be eligible for that based on the conviction in his prior sentence.
Thank you.
Okay.
Your Honor, I just, when I went to prison the first time, I pled guilty and I was sentenced to go to boot camp. And then when I got to prison, they informed me that they didn't know why it was that I was told that, because I had a third habitual felony, which I was unaware of, that making me ineligible. And so I had to file a leave to appeal for that, which I ended up serving in addition to my original sentence, additional time. But I just wanted to make sure that that there is not an objection from the courts for the SAI boot camp if I did qualify for the boot camp. Just so that when I get into the MDOC, if for some reason the information has changed that you might not be aware of, or that the prosecuting attorney might not be aware of, that if I do qualify for it, that there's not going to be an objection, or if there is an objection now, that way I won't pursue that when I do get to MDOC.
Yeah, I understand what you're saying. I don't think that you're going to be eligible. If you were, I would object. I think you need to serve this time based on your conduct in this case. So.
Thank you, Your Honor.
Mr. Ziegler, can you check and see if Mr. Ziegler is available? I want to address Mr. Christie's case. He's not connected, so I'm assuming that the DOC is not going to have him available for us.
Okay.
You still have Jason Wright versus Aaron Weaver.
I do. Doesn't it? Debtor's exam.
Mhm. Ms. Cranberry, can I just ask you a question? This is Mr. Elhart's case.
Yes.
Had a debtor exam set for 11:30.
Yes, I was wondering, I have that file, Your Honor.
Oh, okay.
Yes, I don't know if the other party was planning on appearing, but I do have it and I'm ready for it.
Let's go on the record on that right now. So this is file number 2414403, Wright versus Weaver. We have Ms. Cranberry here on behalf of the plaintiff. This is set for a hearing today, set pursuant to a subpoena for a debtor examination. It was set for 11:50. It's now, or I'm sorry, 11:30. It's now 11:55. Mr. Weaver's not here in the courtroom. Have you checked in the lobby for, see if he's there?
I would be happy to check, Your Honor.
Okay. While we're waiting for that, the court will call People versus Blake Christie, 244933. The record should reflect both counsel are present. This was set for resentencing, and the court was made aware that it did not articulate the statutory requirement of lifetime electronic monitoring at the time of sentencing, so the court set it for resentencing. Mr. Christie is not present, so it would be my intention to reset this for another hearing date. Mr. Seeger, any objection to that?
No, Your Honor.
Mr. Ziegler?
No, Your Honor.
Okay, so Mr. Ziegler, I just asked that you prepare another writ. This was a matter that was set for hearing at 11:15 by Zoom through DOC, and he's not connected, so I don't think he's going to connect by this point. So if you can just prepare another Zoom writ, Mr. Ziegler, once we have the sentencing date.
Sure.
Okay, thank you. Back to Wright versus Weaver, Ms. Cranberry, please get her out in the hallway.
Your Honor, I did check, and no one responded to that particular name.
Okay, so typically what I do under these circumstances, when it's a first failure to appear, is the court would set this for a show cause hearing for Mr. Weaver to appear. So the court will send that to his last known address that we have. And I just I'd like to see if you have an address, and if you do, if it's the same one that we have for him. Looks like the address we have is on Windmill Lane in Rapid City.
One moment, Your Honor. That is what we have as well, a 11946 Windmill Lane.
Okay, so we'll send the show cause and we'll set it for another hearing. Go from there. Is there anything else you want me to state for the record on that?
No, Your Honor, thank you.
Okay, thank you. Great, that's it